Hello, this is Heidi Meyers, immigration attorney, and today I wanted to let you know that the immigration courts will be reopening as of July 6th. That includes major immigration courts, so all the immigration courts in New York City are reopening, all the immigration courts in Texas, including Houston, San Antonio, Harlingen are reopening, as well as Portland, Oregon, Kansas City, Kansas, Memphis, Tennessee. And in other courts, there will be limited hearings scheduled. So if you have a hearing scheduled for July 6th or later, you should plan that hearing will be going forward and you need to be ready. All right, so if you have an individual hearing scheduled, you want to make sure you get all your evidence submitted and your witness list way ahead of time. Many of the immigration judges want evidence submitted at least 2 months ahead of time, some 1 month. And if you're e-filing, it's supposed to be 3 months prior. But you've got to get all your evidence and your witnesses and all to your attorney before that deadline. So you should get all the evidence and information to your lawyer, and you should be working with your lawyer very hard to get everything to them way before that 2 month or 3 month deadline, because the attorney then has to put all the evidence together into exhibits. It has to be served. If there are witnesses, the attorney has to interview the witnesses, make affidavits for them. So you're talking about a very long lead time, and you must not wait until the last minute. All right, so now we will move on to the recent Supreme Court decision in Ms. Chavez versus Garland. Justice Gorsuch issued the decision, the opinion, and his writing is like a dream. If you have a chance to read the decision, you should sit down and read it, because Justice Gorsuch writes so well. All right, so the justices based their opinion on the statute, on the words, on the text in the statute, the Immigration and Nationality Act. And so they looked at the definition of a notice to appear. Well, how removal proceedings are initiated. So that is in INA section 239, also 8 USC 1229A1. And it says, the text of the statute says, notice to appear. In removal proceedings under Section 240, written notice referred to as a notice to appear. And then the statute lists all the information that has to be included in a notice to appear. The notice to appear is the charging document that initiates removal proceedings. So you have to say the notice to appear has to include the charges against the foreign national and the statutory sections, the facts, the acts or conduct, and the violations of immigration law. And also it has to include the time and date and place of the hearing. So the justices looked at the definition, and it said a notice to appear, which means all the information must be included in one document. So the charging document, the notice to appear, must include all the information listed in the statute. So this has to do with a very common situation where the government, ICE, Immigration and Customs Enforcement, issues a notice to appear, the charging document against the alien, against the foreign national, but it does not have a time, date of the hearing. So it will list the charges, and then they'll say to be set for the time and date. So they give the individual a charging document with no time or date. Of course, this is very problematic. And the government's argument, and this was to get around a previous Supreme Court decision in Pereira, was that, well, even though the initial notice to appear did not include the time and date of the hearing and all the required information, well, we sent them, the individual, another notice later on, it's sometime in the future, months or years later, with a notice of a hearing that did have a time and date. So the two documents together are sufficient. So the Supreme Court totally rejected that argument, based mainly on the statutory text. And this was in the context of eligibility for cancellation of removal for non-permanent residents. All right, so the requirements for cancellation of removal are that you have at least 10 years of continuous physical presence in the United States, plus you have good moral character, plus you have qualifying relatives, parents, spouse, or minor children who are U.S. citizens or permanent residents who would suffer extreme and unusual hardship if you were deported. So there is what's called the stop time rule. The stop time, now the justices also, so the stop time rule says that once the notice to appear is served, you stop counting the 10 years towards the continuous physical presence for purposes of cancellation of removal. So suppose, for example, we have a young man named Jose, and he's got a wife and he's got 2 U.S. citizen children, and suppose he entered the United States January 1st, 2009. Right, so if he entered January 1st, 2009, he would have accumulated the 10 years of continuous physical presence by January 1st, 2019. But suppose ICE serves him with a notice to appear with a date of January 2018. So you go from the date of the notice to appear and go backwards and see if the individual has enough time in the United States for the 10 years of continuous physical presence. So because Jose was placed in removal proceedings 9 years after he entered rather than 10 years, even though he remains in removal proceedings for a long period of time, suppose he's in removal proceedings for 5 years or so, he never gets that 10 years to qualify for cancellation of removal. So suppose that notice to appear lacked the time and date of the hearing. So suppose Jose was served with a notice to appear January 1st, 2018 that did not have a time or date, and then the government served him with a notice of hearing later on in June with a time and date. So the government's argument was, well, the two notices together are enough to satisfy the requirements of the statute, so that you would count up to the second notice, which would still only give Jose 9.5 years and not the 10 years for cancellation of removal. So the Supreme Court totally rejected that argument. Once again, it was the government was trying to get around the initial Supreme Court decision in Pereira versus Sessions with this clever argument, well, we can just submit notices piecemeal over years, and as long as the total sum adds up at some point to all that information that was originally required in the notice to appear, then that's enough. So the Supreme Court totally rejected that argument. And they also looked, so they looked at the language defining the notice to appear and all the information that's required, and it said a notice to appear. And then they also looked at the stop time rule for purposes of counting continuous physical presence. And that also said a notice to appear. So service of a notice to appear stops the counting of the 10 years. All right, so it was a statutorily based argument based on words, based on the use of that definite article A. So it can only be one document, and all the information has to be in that one document. All right, so it was a really great Supreme Court decision. Justice Gorsuch writes really, really well. If you want to read it, it makes for good reading, if you like to read that kind of thing. Okay, so what does this mean? So this means definitely if you are in removal proceedings and you have a U.S. citizen or permanent resident spouse, parents, or child, and you would have accumulated the 10 years of continuous physical presence for cancellation of removal, but for the fact that you were served with a notice to appear before you got your 10 years. Now, you've got to look at the notice to appear and see, did the notice to appear lack the time and date of the hearing, or did it lack any of the information that is specified in the statute? So for our example, for Jose, now let's say Jose is still in removal proceedings and it's 2021, then he would have accumulated the 10 years of continuous physical presence for purposes of cancellation of removal under the new Supreme Court decision Inez Chavez versus Garland. So his attorney can go to court and argue to the judge, okay, now because the Supreme Court has issued this decision, my client is eligible for cancellation of removal. Because my client has the 10 years now because the initial notice to appear lacked all the information required by the statute, and the later notice of a hearing that came on down the road doesn't count. Okay, so that's one thing. Then for others, there's also a very good argument that these decisions, both Pereira versus Sessions and now Inez Chavez versus Garland, mean that anyone who was served a notice to appear that lacks the time and date of the hearing or lacks any of the required information would have a good argument for termination of proceedings, that the immigration court never had jurisdiction for removal proceedings in the first place because the notice to appear did not meet the statutory requirements. And serving more pieces of paper later on didn't help the government gain jurisdiction. And it also helps folks who have old in absentia removal orders. So you all with old deportation orders, open up your ears. If your notice to appear, again, did not have the time and date of your hearing, you would now have a good argument that your in absentia removal order should be reopened and your proceedings terminated. So this also offers hope with folks with old removal orders. All right, so that's it for today. And it was very nice to see you all and talk to you all. You can leave your comments down below. If you have an idea of a topic on immigration or on economic sanctions that you would like me to make a video about, just let me know. All right, this is Heidi Meyers, immigration attorney. I'm at 11 Broadway, Suite 925, New York, New York, 10004. And my number is 646-508-5225 or 212-791-4007. And my email is heidimeyerslaw@gmail.com. And don't forget to like this video and subscribe to my channel. Thank you very much. Bye-bye.